It's 2:12 p.m. on Wednesday, April the 21st. The House Criminal Justice Subcommittee is now back in session. Madam Clerk, please take the roll.
Representatives Beck. Here. Curcio. Here. Farmer. Here. Griffey. Here. Hardaway. Howell. Here. Lamberth. Doggy. Moody. Here. Russell. Here. Sexton. Here. Chairman Doggett.
Present.
Mr. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, we are on item number 2, continuing on item number 2 from yesterday. Before we begin, is there any personal orders? Leader Lamberth.
Thank you, Madam Chairman. In the first row is a very good friend of mine and one of my county commissioners, Ms. Deanne DeWitt. If y'all can please make her feel welcome today.
All right, seeing none, we're going back on item number 2, House Joint Resolution 44 by Chair Lady Hazelwood. Without objection, we will go back out of session to hear continuing testimony. We're out of session. Let's see if we can get, let's see, yesterday we heard from it. If you'll come back up, the Attorney General's Conference, Sheriff Bledsoe with the Sheriff Association, Tennessee Bureau of Investigation, and then with the Chiefs of Police, Ms. Maggie Duncan. If you would come up and you'll have seats. General, we heard from you yesterday, so we will start with comments from the others. You will be available for questions when we get to that point. Whichever of you three would like to go first, or what order you'd like to go in, just state your name and who you're with for the record, and you'll have 4 minutes for comments.
Afternoon, Chairman and committee members. Jimmy Music, Tennessee Bureau of Investigation. I know there was a lot of conversation and testimony yesterday, so I will not relitigate all of the discussion that was had then. I just want to start out by saying that, I mean, obviously our whole business is justice and trying to take care of victims. So it's something that is important to us, but given a lot of the concerns that were raised yesterday, especially given what General Crump vocalized, that I think represents most of our sentiment here from the law enforcement community, is that this obviously has a lot of moving parts. And it's something that we take, you know, very personally and professionally important, and we want to do it right. And there are some elements of this that our concern is we just don't know how it would be done properly, and that's a concern. We want to do it right. So thank you, Chairman.
Thank you.
Maggie Duncan, Executive Director for the Tennessee Association of Chiefs of Police. And not to belabor, but I agree with Mr. Music, also with DA Crump. The police chiefs across the state and the law enforcement agencies that they represent are concerned with how we implement this. And so without going into, you know, we've listened to a lot of debate. We're very appreciative of the time that's been taken on this issue. We've worked really diligently on this. We may be at an impasse, but we believe that taking care of victims is our #1 job. Preventing crime is another important piece of our jobs. And as we move forward, that we make sure that victims are taken care of, but that we are doing it correctly and that we're actually able to implement.
I'm Jeff Bledsoe, the Executive Director for the Tennessee Sheriff's Association, and I appreciate this opportunity. Good afternoon to each of you. Our sheriffs have always answered the call to protect our victims and serve our victims when that call comes out for us to respond to a scene. And our sheriffs have been involved, especially our association, since the beginning of this, and we've been diligent to be in all meetings and spent hours upon hours, just as each of you do, to try to work this out and to come together in what language would be in the bill that would be acceptable to all. And but we haven't been able to agree upon the notification procedures and how that relates to our sheriffs. And as some of you so well stated yesterday, there's still work to be done on this at the state level, and we believe with the correct implementation plan and the correct blueprint that we can put in place, knowing the cost of the project, that Tennessee can be a leader in the nation and get this right and have the best protections for our crime victims.
Okay, thank you very much. Members, do we have any questions? Those on our panel, Chairman Curcio.
Thank you, Mr. Chairman, and I want to thank all of you for being here today. And General Crump, I know you spoke yesterday, so thank you also for being here. I know it's kind of strange we had to cut committee off and then restart, so thank you for taking time. Just a comment, really, especially to Sheriff Bledsoe. Obviously, you're the sheriff or former sheriff from my home county of Dixon County, and I have seen you weep for victims. I've seen you bleed for victims, and so thank you for being down here to talk about this important issue. Because again, as we talked about yesterday, none of us disagree on the substance. It's just how do we make this happen? You know, it's the sentiment is in the right spot. It's just how do we make this happen? So I just want to commend you because I know it puts all of you in a very unenviable place. You know, to be up here testifying on something that we all want to see come to fruition, but we just haven't made it to that point yet. So thank you so much for taking time away from your law enforcement careers and from defending victims and working for victims' rights every day to be down here to testify. So thank you.
Thank you. Any other questions? Chair Lady Moody.
Thank you, everyone. And thank you, Chairman, first. But it's very rare that I'm on an opposite side from our great law enforcement team. So you know I love you and appreciate all you do and appreciate you being here. And I think one area I think I'd like to hear more, and I don't know who wants to answer, but the issue with the juvenile crime. Why is that seem to be a line drawn? And I guess just as a non-lawyer, non-law enforcement, the crime is getting worse, and God bless y'all, not any fault of yours, but I just try to wonder, the juvenile crime is on rise, and just looking at it, not trying to be a pessimist, but I'd like to hear more about why that's something y'all don't want.
Good afternoon. Stephen Crump. I'm the District Attorney General of the 10th Judicial District, and I also serve as the Legislative Chair for the Tennessee District Attorneys General Conference. And Representative Moody, you have been a remarkable friend to law enforcement for a long time, and we have absolutely no quarrel with you or your position on this particular piece of legislation. In fact, we don't quarrel with anybody who wants to improve the lot and the lives of victims. The juvenile piece is particularly complicated. It's complicated first by the fact that juveniles are treated significantly differently just as a defendant than an adult is. There are certain privacy requirements that go along with the juvenile system. There is a very limited period of time during which a juvenile can be supervised. There are very limited means for recovery of restitution. And then also there's the component of merely manning that court. In many of our jurisdictions, general sessions and juvenile judges serve in the same capacity, and so they may in 5-day week arraign new juveniles on criminal offenses or delinquent offenses all 5 days, even if they don't hold hearings, but for 1 day. So if you look at all those, the first three really relate to the status of the law as it pertains to juveniles specifically. I think the most troublesome thing is that, for example, take the issue of restitution, and I mentioned that when I spoke yesterday. Restitution, under the Marsy's Law arrangement, victims would have a constitutional right to full and timely restitution for their losses. That is physically impossible in many juvenile cases because the court loses supervision. And so once the court loses supervision, it automatically means that we either aren't fulfilling the constitutional mandate to full and timely restitution, or we're creating some process that ignores the full and timely restitution process that has been enacted in the Constitution. I'm not suggesting to you there are not ways to do that. Sitting here today, I don't know what the answer to that is, but that's an illustration of how a remarkably great intent and something this body and the Senate passed a restitution first bill this year, which Chairman Baggett actually carried. That's a bill that will revolutionize the way victims are treated in this state. There may not be a bill that's more important to victims on a practical level, but it's very different in juvenile court from an adult system where you have ample time to get them to pay back restitution. The privacy issue related to juveniles also can potentially be a problem. Most of the issues in juvenile court can be worked out. I'm not suggesting to you that there aren't ways to work it out, but fundamentally it will require more people because you're going to have somebody there every day to be notifying victims, to be seeing what comes in. You're just going to have to be doing that. And it's not as simple as being able to check a computer docket, because we could check a computer docket and we could possibly get an address. But what if they're detained today and there's going to be a hearing tomorrow and we don't have a way to get in touch with them? We can't send them snail mail, if you will, and it get there the day after the arraignment occurs. So there are practical difficulties that I think require people actually in the courtroom. From the district attorney's perspective, law enforcement will have a different perspective for notification because they will be the ones that will be required to notify a victim that night as to what would happen. And I won't speak for their part of that. I'll let them speak for it. But they have real and practical concerns that will begin long before the DA's office is ever involved in the case. And I hope that answers your question. If you have follow-ups, I'm happy to try to do that.
Thank you for that, and it helped give a better picture.
Any other questions? Representative Hardaway.
Thank you. And thank you again, Mr. Chairman. The problems that we have with the juvenile court issues, are these, Brant, and anyone can jump in on this, are these issues which have just recently come to light?
Do you mean with, thank you, Chairman. Do you mean with this specific bill or in general?
With this bill?
No, these problems we've brought up from the very beginning.
And has the DA's conference been doing any work on this?
Representative, yes, we have. In fact, I was present for the very first meeting that I'm aware of, other than potentially with the sponsors, between the Marcy's Law representatives and the DA's conference. And we brought that up on that day, that there are these significant problems that are issues that may not be insurmountable, but will require work that goes in to putting them into place. The most significant, I guess, the one that we can't do something about is the funding part of it. And yes, people are part of that, but there are also going to be requirements for additional computer terminals and additional bandwidth. And there are all kinds of expenses that we can't appropriate ourselves. The processes we can help work on, but ultimately, juvenile court is a different animal than criminal court, as well it should be. And the most significant offenders out of juvenile court typically are treated as an adult if they are transferred. Occasionally they're not because they're not transferred, but the most significant cases in juvenile court from a victim's perspective, the most serious cases, those go into criminal court where they are treated differently, and we don't have the restraints that we have in juvenile court. But we have, from the beginning, both talked about this problem and looked for solutions.
Does anyone else, Mr. Chairman, anyone else want to respond to that? Because what I'm not hearing is that, yeah, we looked at the problem, we offered a solution, and the solution to me, when you're in negotiations, the art of the deal is to have something in black and white. Was there something offered to the sponsor, Madam Chair? And did she have a counteroffer? I'm interested in knowing how we got here.
Representative
Yes.
Hardaway, from our perspective, the only one that we offer, what we said was, if you all are willing to draft the enabling language and get it in this year, and this was several weeks ago when we met, and it was all of us that were in that meeting. If you will draft the enabling language, we can have Marcy's Law up and going years before it appears on the ballot, because we can have the people in place. You all won't have to do it in 1 year to to comply with the constitutional mandate. You could spread these out over 3 or 4 years. You could include in those juvenile workers. You could include in those the victim witness coordinators. And I want to say to the committee, when we talk about funding, we're not talking about additional lawyers. We're talking about actually victim witness coordinators, assistant victim witness coordinators, from our perspective, who would actually be there on the ground with the victims day in and day out. And so we offered that, and we're not opposed to Marcy's Law as a concept. We're simply saying that these are practical concerns that we also feel very strongly that we swore an oath to the Constitution. And if the people of this state create a constitutional mandate on us, we don't want to just say, well, we don't have the people to do it, so we're not going to worry about it. Our oath doesn't allow us to do that. And frankly, that would be a cavalier way for us to approach what we're doing. And so nobody on this panel has attempted to sit back and not create a solution. We drafted a Marcy's Law version of law enforcement that we were asked to draft a version of Marcy's Law that had minimal fiscal impact and that did as much as we thought we could do. We did that. We gave that to the sponsor. The sponsor and Marcy's Law did not like that version. And so I don't want you to feel like this has been a one-way conversation. It's been a two-way conversation. We just haven't been able to agree on the juvenile piece is certainly one of them. But it's not obviously the only one.
Okay, I'm still not getting a full picture. You did a draft of Marcy's Law and presented it to the sponsor. The sponsor rejected it. Is that where it stopped?
Yes, sir, because it was fundamental differences. It was the difference in, for example, does this begin after indictment, as our current constitutional amendment says, or does it expand into general sessions court and juvenile court? Those are significant issues. And again, the estimated cost just from the district attorney's conference to equip all of our courtrooms efficiently for this to be done effectively from the mandate is $16 million. But it's not just that. We tried to write into our draft, what does enforcement mean? What are the limits of enforcement? We don't want a sentence set aside. We don't want a conviction set aside because of this. We have asked consistently for a long time for a definition of what enforcement would look like. And we've had a lot of conversations about that, and I'm not suggesting that anybody has not dealt with us fairly on that issue. I just think there are fundamental differences about what that ought to look like. Their version says that we won't set aside a conviction, but does that mean a sentence? What does enforcement look like? Does it mean they can hire a lawyer and intervene? I mean, what does that look like? And again, the discussions have been ongoing for 18 months between us and them. And there have been lots of language drafts back and forth. There have been lots of discussions. They have included some of the things that we asked them about. They have put together things that they thought were important for their draft that we couldn't agree to for the reasons I've stated before. This is not something where these two parties have been sitting in one part of the state and another part of the state and not talking. We have talked almost continuously for 18 months, and we come down to 3 real issues. The issues that I've spoken about, which are the expansion to general sessions court, the juvenile court problems, and then the enforcement piece. Again,
Okay, so there is a written document, and I asked about this yesterday, that represents your position.
Yes, sir.
And I just searched my email coming up here. I didn't see anything. Does anyone on the committee have it?
I'm certain that some people have it because they've asked us for it. I don't recall you asking me specifically for it. I'm happy to I'm happy to give you a copy of our version of it, Representative, but I don't think anybody asked me anything yesterday. And so I apologize if I missed it, but I don't recall being asked for a copy of it, but I'm happy to send it.
All right, I made that statement during my Q&A with the judge.
All right, I'm sorry, Representative. I didn't realize that was directed at me. since I wasn't testifying. I apologize.
All right, so we can move things along. You said that you could get things in place years ahead of schedule, as opposed to going with the version and the schedule that would evidently kick in if we pass the sponsors bill. Help me understand that. How would you move ahead years ahead of schedule to put things in place, as opposed to what you would do if the bill passed to put things in place?
Representative, this cannot appear on the ballot until 2026 for the people of the state to determine whether or not they want to add it to the Constitution. My statement was that in terms of the fiscal piece of this, you could, over the next 5 years, with the enabling language that was created for this session, if you pass the enabling language in this session, you could begin the process of equipping all of the courtrooms with the number of people that are going to be necessary, and then have them all in place long before the people ever voted on it. You could, in fact, be doing much of what Marcy's Law is wanting, but it requires that investment beforehand. The position is not, can you do it before or after? What I'm saying is you don't have to wait to pass this. And what we want to avoid is a situation where this General Assembly and the next General Assembly passes it, and the General Assembly after that decides it's not necessary to fund it. That's the trap that we're potentially caught in, is that this General Assembly passes it, and the next General Assembly, for constitutional purposes, passes it again. And then the next General Assembly says, we don't think any money is necessary for this. And so they don't implement any fiscal additional resources for us. So when I say that we could do it beforehand, I just mean you can put all the pieces in place before it will actually appear on the ballot, which is in 2026. If you wait to 2026 and then you start adding in, it'll be 2030 or 2032 before you get them in, unless you want to add $20 million to the state budget in 1 year for it. That's all I was saying.
Okay, I'm kind of feeling like I'm going in circles now, because I think you're saying what I was thinking, that if the sponsors bill passes, that the necessary allocations could begin right away, and by the time it became a constitutional amendment, that the resources and the procedures, the processes, the funding would be in place. Are we saying the same thing?
Yes, sir, and we've said that all along. There's just
Okay.
never been any language to that effect presented to us.
All right. Thank you, Mr. Chairman. Thank you, sir.
Representative Hardaway, I just want to make one clarifying comment. And when you asked about that timeline, I think I know what General Crump was saying, but we had a meeting on March 11th. That was a Thursday after the floor session. We met, we wrote our draft over the weekend and got it to the sponsor on Monday. They did produce another draft after that. I think we got it 2 weeks later. So I just wanted to make sure that you understood it did not end on that Monday after we sent that.
All right. Thank you, sir. Thank you for the clarification. Thank you, Mr. Chairman.
Yes, sir. Thank you. Representative Beck.
Thank you, Mr. Chair. And I asked the judge this yesterday, and she didn't know, and I don't know which one of y'all would like to respond, but I asked her what was the difference between Tennessee's law on victim notification today as compared with what they were requesting in Marcy's law for victim notification. Can anyone address that?
I think we'll each address it a little bit differently, because we each have different components. From the state's perspective, it would involve from the initial appearance, a notification prior to that initial appearance at arraignment, and then at bond hearing in general sessions court, or initial appearance in juvenile court. We currently are not doing that. What we're currently doing in Tennessee is, once a case is indicted, presented, or opened by information, according to the Tennessee Constitution, those rights begin at that point. So the main difference in what we're talking about here is the notifications that currently take place in criminal court would be expanded to general sessions court and to juvenile court.
So, General Crump, you said bond hearing and arraignment, and you said a third thing I didn't catch.
Initial appearance in a juvenile proceeding. but it would begin in general sessions. Then each time there was either a continuance or a hearing of any kind, additional notifications in general sessions court. And to give some sense of a difference, that takes the case count that we currently manage from about 250,000 cases a year statewide to about 1.3 million cases a year. It would require us to maintain a file on every general sessions case with a victim in it. And the definition of victim is not necessarily contained in the Constitution. That could increase from that number depending upon how a victim was categorized. For example, if a victim of crime was defined as somebody who is indirect or who directly suffers as a result of it, you could be somebody borrows a car from another person and is in a wreck because of a DUI. That person could end up being a victim. And again, not suggesting we don't want to talk to that person, just saying that expands the number as the definition expands.
Representative Beck, we only have one system currently that helps to identify for our victims, and that's administered by the Tennessee Sheriff's Association. That's SAVIN, which stands for the Statewide Automated Victim Information Notification System, which a person can register and sign up for that, but it does not apply to juvenile criminals at this point because of all the protections in privacy and confidentiality that's that umbrella that is placed over the juvenile court at this time. So we would have to expand that and change the laws to pull the juvenile offenders in.
Does that system apply to general sessions?
Yes, sir. It's through any of the court system. It begins upon booking. Once that person is entered into the booking system and all 95 counties participate, you can go online, register. It can send you a text message or an email or a phone call to let you know on 3 parameters, whether that person is released from custody or they're transferred to another facility or they're transferred out for court or they escape custody. So there's 3 parameters that would give notification.
And so the only change that would affect Sheriff's Association with that program would be adding juvenile if the law is allowed.
Yes, sir. We would have to build out that system to include if you allow it by the law. Yes, sir. I don't know what that cost would be to include all of the juvenile detention facilities because it would have to trigger upon, I would say, on intake when they go into the juvenile facility, and then it would do the same mechanism for our victims. And then hopefully our goal is one day we'll have the court module added to that to where it can be tracked in the same type system, which they do have that. The group that provides this system for us statewide has that in other states.
Very good. Thank you.
Representative Beck, you have any other questions for the members?
No, Mr. Chairman. Thank you.
Thank you. Chairman Howe.
Thank you, Mr. Chairman. I've listened to all the testimony, and I must say it's very compelling on both sides. Full disclosure, General Crump is my district attorney, and I have observed firsthand the job that his office does, and they do, I think, an outstanding job with the resources they have available in taking care of victims' rights in District 10. It's commendable. And I think it's safe to say that no one before us today, or no one on this dais, is opposed to enhancing victims' rights. I think everybody agrees on that. I think the problem comes in the nuts and bolts of the details. And I've done a lot of study about this, done some research, done some reading, listened to what other states have done. And of course, we have various avenues through which we can find out how it's working in other states. We've heard a lot about Oklahoma during testimony. A couple of weeks ago, we had, I believe, a professor from Oklahoma that told us what a good job he was doing, was working in Oklahoma. I found that interesting, and have a quote here from, Mr. Chairman, if I may read this, if you don't mind. His name is Trent Baggett. He's the executive coordinator with the District Attorney's Council of Oklahoma. Here's what he said about Marsy's Law in Oklahoma. Oklahoma passed this, Marsy's Law, a couple of years ago, we had pretty robust victims' rights laws already in statute, but this memorialized it in our Constitution. Much like Montana, the time commitment to this has been huge for most, if not all, of our offices. Our DAs do the best they can, but it isn't enough. Recently, I heard that it is also starting a cottage industry in the defense bar to sue on behalf of victims that their rights have been infringed upon. We are experiencing growing pains with the implementation of Marcy's Law. We certainly want to abide by the law and not be a thorn in the side of victims. I also know that when a prosecutor has 500 plus new cases each year, there are only so many hours in a day. End of quote. And I think that's what I hear my general saying and what the witnesses are saying here. We want to do the best we can for victims, but we want to do it right, and we don't want to be caught in a trap like Oklahoma, and I hear a similar situation in Florida, similar situation in Kentucky, where they said, let's do this, but there was no implementation, a language, and no resources given. I want to do this, but I want to do it right. And that's the job of a subcommittee, is to make sure that we pass good policy. And I think that's why I've enjoyed hearing this compelling testimony. My heart grieves for the victims. There's nothing at all that we can do now for the victims in the past, but there is something we can do about the victims in the future. But it's incumbent upon us that we do it right. And that's why I feel like this does need further study and further work. Thank you, Mr. Chairman.
Thank you. Representative Moody.
Just one quick thought for my brain. How are y'all, what is your definition of victim? How do you define victim? Is that?
You may have stumped us.
I'll take a stab. I don't know that I've got a good answer for you, except, there was a previous version that did have some definition of a victim and I just don't know because, if you looked at that one, and I don't want to get on a sidebar about something that's not in what's before you all now, but it could be very expansive or very narrow. But I think that what this point brings up is why that enabling language would be important for us to know that, to know what the scope of the universe is that we're going to be operating in.
Representative Moody, the current constitutional Bill of Rights has victim in it, and there's no definition of it. But because victim, from a notification standpoint, and in all the cases that we've been talking about, happens after indictment, then it's more defined from that aspect, I would say. So that's how we currently handle things, and so we don't currently limit specific types of victims because we try to treat every victim equally.
All right, thank you.
I was going to say that our office, the way we do it is each assistant is required to review the file and determine what losses have been suffered by a victim. Obviously, in a crime against a person, that's easy, typically. Mm-hmm. But in a property crime, it can be more complicated. And so we don't go by a standard necessarily definition because it's hard to say. And sometimes, for example, if there is insurance involved, while you may have a victim that's an insurance company, the General Assembly has said they can't be treated as a victim. So even though they have a direct loss because they paid for the damages to somebody's vehicle or somebody's medical bills or whatever, they can't be reimbursed. And so that also complicates what is a victim and what is not a victim when it comes to saying a victim has a constitutional right, for example, again, to restitution.
Thank you.
Any other questions for our guest? Seeing none, we will, I want to tell you all thank you for your time here today. Thank you for being willing to speak with us and answer questions.
Thank you, Chairman.
Without objection, we're going to go back into session. Chair Lady Hazelwood, you are recognized.
Well, thank you, Mr. Chairman, and I know that a great deal of time in this committee has been spent on this, and I appreciate it. I'm not going to go back through what Marcy's Law does. I think everybody here has a pretty clear understanding of that, but I do want to make a couple of points about it before I attempt to respond to some of the points that were made here during various testimonies. First of all, Marcy's Law, I really am proud, and I know that everybody on this committee, I think everybody in this legislature wants to protect and make sure that victims are taken care of. I don't think there's any question about that. We have some good legislation. We have a constitutional amendment that addresses victims' rights already in our Constitution. However, as I think the point has been made a couple of times by some of our expert witnesses, that was ahead of its time when it was passed and implemented in the Constitution in 1998. It is now behind the times for various reasons. And one of the things that we need to make sure of that we adapt our Constitution to these moving times, and we need to make sure, in my mind, a lot of conversation has been about why don't you do some of these things statutorily? The answer is because can easily be changed by future legislators. And I don't think it's hard to see which way the wind is blowing in terms of whose rights are getting the most attention at this point. And I think most of us would agree that the perpetrator of the crime is sometimes getting a lot more leeway than the victim of the crime. So it's important that we get this in the Constitution. As we see from this process, that's very difficult to do a constitutional amendment. This is the poster child for that, and it shouldn't be easy to do. But again, the need for it, that is why we need to make sure that victims' rights are protected in perpetuity and that they're protected to. A lot of things have changed since 1998 in terms of how we communicate. There are conversations about how we notify and whatever. Not very many people left in this country above the age of 8 don't have one of these and don't have a text number that you can send information to. So, it's just a different world. I also want to make another point. I think everybody understands it, but just in case, this is not about giving a victim a veto of any conviction. It is about giving a victim a voice. It is about allowing the victim not even a seat at the table, but at least a seat in the room and an opportunity, if they feel that their concerns haven't been heard, to go to a judge and say, please let me speak on the record. Let me try to make people understand how I've been impacted by whatever crime that it is. But what I really, all the conversation that we have heard for the past 2 days and even prior to, I want us to remember, I think we're getting some things kind of melded together that are actually separate. We're talking here about a constitutional amendment. Constitutional amendments don't normally come with you don't put into the constitutional amendment all the statutory requirements. First of all, Tennesseans are not going to read pages and pages of statutes. The constitutional amendment is an overview. That's what Marcy's Law would do. And as the judge mentioned in her testimony yesterday, and as was mentioned here by some other folks in testimony, we have 6 years to get it right. But we don't need to wait 6 years to get it right and then do the constitutional amendment. The earliest that this can be on the ballot is 2022, and not the next gubernatorial election, but the one after that. So we have this time, and in multiple meetings, I have asked, I have requested, Marcy's Law and you guys know I am definitely not an attorney, so I'm not in a position to draft enabling language. I have asked the folks that were up here previously to do that, and what I have asked them to do, what I'm asking you to do, is to allow these things to move on parallel tracks. we have an opportunity to move Marcy's Law forward. At the same time, and you have my commitment and the commitment, I think, of other supporters of Marcy's Law, that we will work to make sure that the statutes that are necessary to make it work are in place, and we'll work on the funding, because nobody denies that there will be funding issues. I think a lot of that funding is to be determined based on things like the definition of a victim. That discussion, we had a little bit of that here. And I would point out that at one point, we had the definition of a victim was in the Marcy's Law that would have narrowed that definition and addressed some of the concerns about personnel required and that sort of thing. We took that out at the request of the other side. We also, we keep hearing that we had, that it needs to be, the problem is the implementation. Everybody's good with the idea. The problem is the implementation. Again, I come back to the fact that is for this committee and all of us in the legislature to work through during the 6 years. But again, I'm asking you on behalf of the victims that testified yesterday, on behalf of all the other victims that are not here and can't be here, some who are no longer walking this earth because of horrendous situations, I'm asking that we move this forward. And I would also like to address the fact that there was, at some point, one of the folks testified that this was not Tennessee specific. We have sort of a circular argument going, because then there was testimony, and I will tell you this is very Tennessee specific because we've been working on it for 18 months to make it so. Marcy's Law, as written, that you are looking at, is not the same as Marcy's Law in other states because Tennessee is not the same. We've worked very hard on that issue to make it Tennessee specific. And when if you really listen to a lot of the discussion and a lot of the argument, this comes down to money. I mean, that is the bottom line. And as the judge mentioned yesterday, nobody says to the defendant, we don't have enough money to afford you your rights. I don't think we should say that to the victim either. This should be doing about the right thing. Taking care of victims, giving them a voice, that is the right thing to do. And I think we can figure it out. We've got a lot of bright people in this legislature. We have a lot of bright people that will be coming after us. And I think that we can figure that out. We can come up with the statutes that will make this work. And I'm asking you to move this forward. Thank you, Mr. Chairman.
Thank you. First on my list is, from yesterday was Representative Sexton. Do you wish to speak now, or do you want? Okay. All right. Next is Leader Lamberth.
Thank you, Mr. Chairman. Just a general comment, and to the sponsor, I've watched you literally, negotiate as part of the budget process, a multi-billion-dollar budget. I've watched you involved in a multitude of different bills, and there's rarely a time that I've seen you put more energy or passion or effort into an issue other than this. So I say this for the advocates of this particular bill. You could not have possibly picked a better sponsor. And I just wanted to say that out loud because I know this is something that is extraordinarily important to you. And I, don't know exactly what the vote will be today, but I know that this is something that is a lifelong pursuit for you to make sure to support these victims, and in this bill and any other bill. And so I just really, really appreciate that. I say that as your friend and as your colleague. We see a lot of folks coming to this committee, and there are folks that sometimes we see come to the podium, and it's clear that they are carrying a bill for somebody else or something that somebody's asked them to do. But sometimes, honestly, you can kind of tell that somebody's heart's not into it. I know that yours is into this. And so I just wanted to say thank you. And on behalf of these victims and everyone else, I appreciate the fact that you have been a true champion for them. And so thank you for the probably hundreds of hours that you put into this at this point, and we appreciate your leadership on this issue.
Thank you, Leader.
Thank you, Representative Griffey.
Thank you very much, Mr. Chairman. I share Chair Lady Hazelwood's concerns and interest in this. I think it's the right thing to do for Tennessee. I also hear the concerns of law enforcement and the district attorneys about implementation. I know they don't want this moving forward, and then if it's not funded, they'll be the ones that get blamed for it not proceeding as it needs to. And I would suggest that we should pass this, and then we should come back and let the DAs and law enforcement come back and tell us how much it's going to cost to implement this, so that when if it moves forward and goes to the voters will have an idea of what it's going to cost, and if they want the state of Tennessee to put those resources towards victim rights, that gives the voters a chance to decide that. And I'm also a co-sponsor on this bill, and if I may, I would like to move for a roll call vote on this legislation, please, Mr. Chairman.
Okay, it'll require 3 hands for a roll call vote on this. Okay, we have 3 hands, so 4 hands. So at that time, we will have a roll call vote. Any other questions? Representative Hardaway.
Thank you, Mr. Chairman. And I feel like I've grown in this just since yesterday. I've done a little reading, done a little talking and dialoguing with constituents. And I'll know where I am when I vote. What I'm still trying to figure out is if we know how long we have before we need to have the monies and the policies through statute in place. Why is it we can't get started now on the amendment? Now, I was unsure, but General Crump tells me that there has already been written proposals back and forth. I didn't get my hands on any, which suggests to me that we're already making progress on that. If we have a deadline, we have a deadline. If it comes time to implement it, I see no reason why the same folks who may or may not decide to move it forward wouldn't have the common sense to put the statute, and I'm assuming most of that would have to come through here, in place in a timely fashion. I sat, Mr. Chairman, listening to the George Floyd trial yesterday. Not the trial, but the actual verdict. And along that same time, I received a couple of messages from domestic violence victims. Victims who are victims of the perpetrator and of the system. Okay? And some of, if not at least half of these items in the amendment would apply directly to them. It's like they wrote it. Okay? And then looking at the family of Floyd and their expressions, understanding how they were able to keep up with the proceedings, a lot of that because of the glare of the cameras and the notoriety of the case itself. And it got me to thinking about justice delayed is justice denied. After listening to those ladies who braved what some would say is embarrassment, some would say exposure, and the misfortune of being on record forever, reciting their experiences. After listening to them yesterday, after listening to my constituents later that day, justice delayed is justice denied. And I'm not comfortable at this point in delaying this any more than it's necessary. When General Crump spoke, he helped me to move more towards. Let's get it started and fill in the blanks so that if it's a successful amendment to the Constitution, that things will be in place. Everyone on this committee understands their duties. They understand the challenges that come with budgeting. You're an expert on that, Madam Chair. So I'm having a difficult time delaying anything that will give the rights, give that comfort, that peace of mind, that safety to victims and their families. And after listening to the explanation from General Crump that, yeah, we are moving along and we have plans, we have negotiations, we've got documents flying back and forth, I don't see why we can't do it. I'll still wait until the actual vote to make up my mind, but I've moved and grown since yesterday. And that phrase, Mr. Chairman, justice delayed is justice denied. I just can't, with good conscience, sit here and not contemplate whether the full measure of justice, not some degree of justice, is what the victims deserve. And if we can make that happen, justice in a timely fashion, then that's my commitment. So I'll be thinking about whether, which way my vote goes on whether we can make this happen in a timely fashion. All right. Thank you, Mr. Chairman.
Thank you. Representative Russell.
Question on the bill.
Question's been called. Any objection? Seeing none, we will now be voting on sending HJR 44 as amended on the full criminal. Madam Clerk, take the roll.
Representatives Beck,
Aye.
Curcio. No. Farmer. Aye. Griffey. Aye. Hardaway. Aye. Howell. No. Lamberth. No. Moody. Yes. Russell. No. Sexton. Chairman Doggett.
No.
Mr. Chairman, you have 5 nays, 6 ayes. No, I'm sorry. You've got 5 ayes, 6 nays.
I preferred the first count.
5 ayes, 6 noes. Resolution fails. It'll be referred to the special calendar for this committee.
Thank you, Mr. Chairman. Thank you, committee.
Yes. Representative Hardaway.
Thank you, Mr. Chairman. Is a special calendar a summer study calendar?
No, sir.
What's special about that calendar? I'm asking for
Clarification?
Sir?
You're asking for clarification on that?
Yes, sir. Just in case one of the folks out there in video land want to know.
The special calendars, because the bill, this posture had been rolled to its third and final roll that it had for calendaring. And so there's only 2 things that it could have done. It could have passed on to the next committee, or if it failed, it would go automatically to the special calendar, in which from that point, it will be referred back to the clerk's desk. Because it had been rolled 3 times onto this final calendar, there is no opportunity for a summer study motion or other motion for that matter.
Thank you, sir.
Yes, sir. Thank you. Next item on our calendar, item number 3, House Bill 1546 by Vice Chair Weaver. Without objection, we will roll this to the first calendar of 2022. Item number 4, House Bill 1367 by Representative Lynn is taken off notice. Item number 5, House Bill 1393 by Representative Shaw is off notice. Item number 6, House Bill 735 by Representative Miller, off notice. Item number 7, House Bill 1167 by Representative Harris. Okay. Members, we'll roll this to the hill of the calendar. Item number 8, House Bill 673. Without objection, we'll roll to the first calendar of 2022. Item number 9, House Bill 1565 by Representative Freeman, will roll the first calendar of 2022. Item number 10, House Bill 864 by Representative Chisholm. We will roll him to the hill as well. Item number 11, House Bill 1308 by Representative Chisholm. Roll to the hill. Item number 12, House Bill 897 by Chairman Curcio.
Thank you, Mr.
Motion
Chairman.
second, you're recognized.
Thank you very much, Chairman and committee. Members, for many years we've been examining our pretrial population. We've been looking at what's going on in our criminal justice system. We're talking about all manner of reforms, and these next two bills, House Bill 897 and the one following it, were brought to me by a Senate sponsor who was very interested in digging into this issue. And I believe, as I think that Senator believes, that when we're looking at pretrial, when we're looking at the issues surrounding our criminal justice system, to me, there's not one thing. There's a million little things that contribute to the overcrowding in our jails and the other things that plague our criminal justice system. And so these next two bills deal with one particular topic that I think needs a much longer discussion. And so in conjunction with the body down the hall, I would ask that we move House Bill 897 to summer study.
All right, you have a motion to summer study. It's been seconded. Any objection to that?
Thank you.
All right, members, without objection, sent to summer study. Item number 13, House Bill 898 by Chairman Curcio.
Thank you, Mr. Chairman. Same applies here. This is on the same topic, and again, there's not one thing here that I think we can put. There's a lot of issues that we need to discuss, and so again, in conjunction with my Senate sponsor, I would ask this be moved to summer study.
Second. All right, a second proper motion. Any objection? Seeing none, send it to summer study. Item 14, House Bill 1406 by Chairman Curcio. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman. Thank you, committee. I want to make sure
There's an amendment. Do you want to?
Yes, sir. That amendment is coded 4896.
That
I
is
wish to
correct.
move that.
You have a motion and a second on the amendment. You're recognized.
Thank you very much. Give me 1 second. So, members, this bill as amended comes from some work done over the summer to analyze and improve law enforcement's use of force policies. On July 2nd, 2020, Governor Bill Lee announced a partnership with the Tennessee Association of Police, TACP, the Tennessee Sheriff's Association, the TSA, the Tennessee Bureau of Investigation, the Tennessee Department of Safety and Homeland Security, the Tennessee Highway Patrol, the Tennessee Department of Commerce and Insurance, and the Tennessee Peace Officers Standard and Training Commission to enhance policies, improve information sharing, and increase officer training. This partnership resulted in the Governor's Use of Force Policy Committee, which issued recommendations on September the 10th, 2020 in the form of a sample use of force policy for law enforcement agencies to adopt across the state. This bill, as amended, seeks to codify these best practices to ensure that the men and women of law enforcement continue to excel in their role of keeping Tennesseans safe. And I want to say that in Tennessee, we lead. We have a history of leading. I want us to continue to lead. And as I spoke with members of law enforcement from across the state on this issue, what many of them said was, Representative, we don't engage in a lot of these practices. Our local policies and procedures say that we cannot engage in these practices. And so the request was actually that we have a piece of legislation that codified a statewide standard to show that Tennessee leads. And that's exactly what this is today. This is a way to show the rest of the country how we truly are leaders in this and many other areas when it comes to law enforcement. And I would happy to take any questions, but I seek passage of this amendment.
Thank you for that. We're on the amendment. Any questions for the sponsor on the amendment? Question's been called. Any objection? Seeing none, we're now voting to add Amendment Code 4896 on the House Bill 1406. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. You adopt. We are now on House Bill 1406 as amended.
Thank you, Mr. Chairman. I renew my motion.
Thank you. On my list here, I have Leader Lamberth.
Thank you, Mr. Chairman. And Mr. Chairman, we've talked about this bill before. I am fully in favor of every aspect of it except for, I believe it's Section 5, the very last section that deals with no-knock warrants. These are rarely ever used. I would have preferred a bill, and you've done the labor on this. You've worked with all the groups. Law enforcement is in favor of this. They do not have any objections. This is a personal objection just based on circumstances that we have had in our community where no-knock warrants literally save lives, both law enforcement officers and those they are interacting with. It is a rare occasion where no-knock warrant should ever be utilized. It would have been my preference if we would have been able to put some very stringent guardrails on that process and say that only in an instance where the subject of a search warrant has made a direct threat toward law enforcement. And the situations that I'm talking about are when you have someone who is actively out on social media or has made statements to others that they will kill the next officer that comes through the door or tries to arrest them. In circumstances like that, a no-knock warrant I feel like would be appropriate. This bill does ban no-knock warrants completely. I understand the policy provision on that. Again, I support every aspect of the bill except that one. I merely wanted to point that out, that you have worked with law enforcement. They are all well in favor of this, and that is the only provision of this bill that I have any concern about whatsoever, and just wanted to state that publicly. Thank you, Mr. Chairman, for your leadership on this issue.
Thank you, Mr. Chairman, and thank you, Leader Lamberth. And I know that is an issue that you brought forward and that we've spoken about with law enforcement. So I do appreciate you voicing that. We do feel like this is a step in the right direction. And again, this was an effort that we wanted to bring forward as a way to work with law enforcement to show that we are doing things right. And so, but I very much appreciate your leadership and your comments.
Thank you for that, Representative Griffey.
Thank you very much, Mr. Chairman. Thank you, sponsor, for bringing it. And Leader Lambert for the confirmation. I think law enforcement indicated they don't have any problems or concerns with the legislation as it's drafted. And based upon that, I'll be supporting your legislation. So thank you.
Representative Hardaway.
Thank you, Mr. Chairman, and thank you to the sponsor. This bill is pretty much my Christmas wish list. And that's, yeah, and that sandwich. I think in the climate that we're in, this bill will go a long ways towards reestablishing the trust factor between law enforcement and the citizens of the state of Tennessee. I think without that trust factor, neither law enforcement nor the citizens are as safe as they could be. Law enforcement can't properly do its job without the trust of the citizens, and vice versa. that communications and intelligence exchange and sometimes the actual physical protection of one for the other is necessary. So I thank the sponsor. This hits a lot of the spots. It fills in a lot of the blanks that has kept the community in turmoil. If there's anything that we need to understand after seeing the national displays of not intentional all the time. Sometimes mistakes are made in the field. The fewer opportunities there are to make a mistake, I think the safer our law enforcement agencies are going to find their members are. I think the safer we're going to find our citizens are. So I thank the sponsor. These safeguards, the way that we spell things out gives us uniform expectations across the state of Tennessee on what citizens should expect, and law enforcement has a pretty good idea of how to direct their actions. So I thank the sponsor. I'm definitely supporting it. Of course, like Lita Lambert, I could fine-tune it, but I'm going with this because I believe it's the right thing to do for the citizens, and it's the right thing to do for our law enforcement agencies, our agents, our officers, especially those in the field. So I thank you for it.
Thank you, Mr. Chairman. And members, I just want to say, and thank you for your comments, Representative, but I'll tell you what's on my Christmas list and everybody else's is to see a day when everyone has an equal respect for each other, whether that's a member of law enforcement or a member of the public, and that we can all see Tennesseans being as safe as possible. And I know that's what this committee works very, very hard to do every day. I just want to point out that this legislative body is consistently voted one of the most conservative legislative bodies in the nation, if not the most conservative legislative body in the nation. And this bill did pass the Senate with 32 ayes and no nays, came out of Senate Judiciary with no votes. So this, again, is a way that we can show the nation that Tennessee leads and we continue to lead. And so, again, with that, I move passage.
Thank you for that. Any other questions from our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on House Bill 1406 as amended to go on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. It moves on. Thank you. Yes, sir. Leader Lambert.
Mr. Chairman, I know sometimes we just record ourselves as the clerk, but if you can record me as present, not voting.
Next item on our list, item number 15, House Bill 1449 by Chairman Curcio.
Thank you, Mr. Chairman.
We have a motion and a second.
Thank you, sir. And I have an amendment coded 7241.
All right, you recognized on amendment.
Thank you, Mr. Chairman, and thank you, committee. Members, this bill, this amendment that we've just moved, seeks to right what I see as a wrong, or rather something that we need to examine. Last year, this body, in its wisdom and leadership, voted in conjunction with the body down the hall. The governor signed into law legislation that would reform our drug-free zone laws in this state. A law that, while was well-intentioned, drew far too many people into a net of a mandatory minimum prison sentence. And as we talked about last year on the House floor and all through committee, we had folks, unfortunately, who were caught in the wrong place at the wrong time, certainly doing wrong. And I let me be the first one to say they were doing wrong, but were serving mandatory minimum prison sentences that outpace those of rapists and murderers for having, say, a small amount of personal use cocaine on them when they were pulled over within 1,000 feet of a school, having no intention to go to that school and endanger those children. I won't relitigate that bill, but I just want to paint a picture of what we did last year, and I thank the members of this body for at least listening to that and involving themselves in that debate and that discussion. Not everyone supported it, but it did pass both chambers and was signed into law by the governor. This discussion here is about what happens with those right at 500 folks who are sitting in prison under that old system that does not exist anymore. Let me be the first to say, all of them did wrong. Every single one of them broke the law. I am not advocating for any sort of broad clemency. I'm not advocating for a get-out-of-jail-free card. I do not think that every single person that happens to have been incarcerated under that old law was otherwise completely innocent. I realize there are multiple charges on a lot of those folks. I will say there's about 48 of them who are serving, and that is their only charge, and it was their first-time offense. But for most of them, that is not the case. What this amendment sought to do was to create a review process, to just say, let's look at this defined population. We know how many people it is. It's not going to grow. It's encapsulated. We can pull the data from TDOC. We know exactly who they are. We know what those cases are. But this amendment would seek to create a process whereby those cases could be reviewed. And in many cases, after following that review, the parole board or the court, whomever we go to, could very well make the determination that they need to stay right where they are for as long as we sent them there. But in other cases, they may say, no, this was too much. The punishment did not fit the crime. But I also think that this idea needs much more discussion. And so with that, one second. Thank you, pardon me. With that, I want to move this bill off notice.
Okay. Any objection to moving it off notice? Seeing none? And take it off notice. Next item, number 16, House Bill 802 by Representative Griffey.
Thank you, Mr. Chairman. I'd like to roll item number, I think it's 16 and 17, 802 and 803 to next year, first calendar of next year, please.
Okay. Any objection? Item number 16, House Bill 802, without objection, be rolled to the first calendar of 2022. Item number 17, House Bill 803 by Representative Griffey. We will need a motion and a second on that first. You have a motion and a second. Representative Griffey, it cannot go, you can't roll it because of the number of rolls that is taken. It'll have to go to the special calendar. So you can either, you can take it off notice. Oh, it has to go to special calendar. It'll have to go to special calendar. So any objection, we'll move it to special calendar. Next item, House Bill 1312, item number 18, 1312 by Representative Hardaway. Or excuse me, I'm sorry, thank you. I'm out of service again. House Bill 1321 by Representative Hardaway.
Thank you, Mr. Chairman. House Bill 1321, it's pretty simple, but it's going to have a strong impact on the community. It speaks to reckless endangerment in terms of those who are shooting into crowds of two or more. It also speaks to those who would shoot from within a motor vehicle into a motor vehicle. One of the things that I couldn't believe is you could have this type of road rage and drive-by shootings and still keep your driver's license or go get a driver's license. So that's in here that 5 years from the conviction under this statute, that you would not be eligible for a driver's license except as under the amendment, Mr. Chairman, which we did not put on, I don't believe, which was the untimely filed amendment.
What's that amendment number there? 7434, is that the one you're looking for?
Well, you're right, the part about looking for it, Mr. Chairman. Yes, sir, it is. It allows for the issuance of a restricted driver's license.
Okay, thank you. We will need a motion to consider an untimely. Okay, Representative Farmer.
And I would ask that you put that on.
Yeah, thank you. I just wanted members to know, I looked at this, I believe this was rolled to 2022 in the Senate, and I think that since it was untimely, I believe Department of Safety wanted to speak on it, however, wasn't able to because they have issues with that this is going to issue a new class of driver's license. So I just wanted to make the committee aware of that. Thank you.
Mr. Chairman, I'm unsure.
Go ahead, Representative.
Mr. Chairman, I'm unsure of the creation of a new class of driver's licenses. I haven't heard from the department. I'd be interested in hearing from them and, if necessary, make the necessary adjustments.
Leader Lamberth.
Mr. Chairman, and I'm looking at my good friend from Shelby County at this moment. We have 98% of the rest of the calendar that went to 2022, where the members went ahead and put their bill over in 2022 and worked on and intend to work on it between now and then. It is your one of two. I have a motion that I would like to make, unless the member would potentially consider that themselves. But it I think would be most appropriate to put this in the same posture where all the rest of the bills that were deferred in the Senate to 2022 potentially went. But I don't want to do that without at least hearing from the sponsor of the legislation.
Representative Hardaway.
Thank you, Mr. Chairman. I'm going to ask that the committee would move, well, I believe that for the sake of making the amendment available to the public, that we put it on. And after that, Mr. Chairman, I would ask that you ask the committee to move the bill to first calendar of 2022.
So moved. Second.
Okay, we are on the motion to consider the amendment, so we will need a vote on that. Okay, you have a motion second. All right, those in favor of the untimely filed amendment for consideration, say aye. Aye. Those opposed, no. The ayes prevail. Now we're on Amendment Code 7434 by Representative Hardaway.
Question on the amendment.
Question's been called on the amendment. Well, he'll need a motion in a second on that amendment. Okay. You recognize on the amendment. Now, question has been called. All right, we're now voting to attach Amendment 7434 on the House Bill 1321. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. And now we're on House Bill 1321 as amended. Representative Hardaway, you have something you'd like to say.
Thank you, Mr. Chairman. I'm going to ask that and I appreciate the indulgence of my members, I'm going to ask for this to be rolled to first calendar 2022.
Okay. Motion is moved and seconded. Any objection? Seeing none, we'll roll House Bill 1321 as amended to the first calendar of 2022. Brings us back to item number 7. That's down at the heel of the calendar. Item number 7, House Bill 1167 by Representative Harris, been taken off notice. We'll take up item number 10, House Bill 864 by Representative Chisholm. You have a motion and a second. You're recognized.
Thank you, Chair and Committee. I brought to you House Bill 864, and what this bill does is expands the offenses of assault against a first responder and aggravated assault against a first responder to include offenses against nurses. With that, I'll stand by for any questions.
Any questions for the sponsor? Representative Beck.
I'm kind of shocked. I thought that they would have already been covered under first responders. So I appreciate you bringing this bill. Thank you.
Question has been called. Any objection? Seeing none, we're now voting to send House Bill 864 on to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We move on to full criminal.
Thank you, Chair. Committee.
Item number 11, House Bill 1308 by Representative Chisholm. Your motion and second, you're recognized.
Thank you, Chair and Committee. This bill prohibits the application of bail bond deposit made by or behalf of a defendant to the payment of a judgment or fine or court costs or restitution entered into the prosecution of a cause except for bail forfeitures. But seeing the posture that this bill has in the Senate, I want to roll this bill to the first calendar of 2022.
Your motion second on that. Any objection? Seeing none, we'll roll this to the first calendar of 2022.
Thank you, Chair. Thank you, Committee.
Yes, sir. Thank you, sir. Members, we have completed our regular calendar, and we will take up our addendum calendar here. Item number 1 on the great addendum calendar is House Bill 733 by Representative Smith. You have a motion and a second. You're recognized.
Thank you, Chairman and Committee. This bill does have an amendment that makes the bill. It is amendments number 6819.
Okay, you recognized on the amendment.
All right, thank you, Mr. Chairman and Committee, and I appreciate the patience of this committee on this particular bill. In current code, aggravated cruelty to a domestic animal or a companion animal is defined as an act that's done or carried out in a depraved and sadistic manner in which tortures or maims an animal, including the failure to provide food and water to a companion animal, resulting in substantial risk of death or death. In its original form, unamended, this bill passed through, and we inadvertently took out that last phrase of substantial risk of death or death. This amendment adds that back on, in addition to removes the more subjective definition of depraved and sadistic by rewriting the definition to be or specifies a person commits aggravated animal cruelty to a companion animal when, with no justifiable purpose, the person knowingly kills, maims, tortures, drowns, suffocates, mutilates, starves, or otherwise causes serious physical harm to a companion animal or fails to provide food or water to the same companion animal, resulting in substantial risk of death or death. And with that, Mr. Chairman, I will take questions.
Thank you very much. Leader Lamberth, you're recognized.
Thank you, Mr. Chairman, and thank you for coming back to subcommittee on this bill and amending it to catch what would have been, I think, a pretty egregious error that is not your intention, where substantial risk of harm had been left out of the amendatory language. That would have, again, done the opposite of what you're intending and would have allowed for some animal abusers not to be prosecuted. And so I thank you for coming back to this subcommittee. That's what the committee system is for, is to make sure that we get it right. So again, thank you for entertaining the amendment.
Thank you. Any other questions? We're on the amendment. I do have a question. Does this apply to livestock animals?
Thank you, Mr. Chairman. It does not apply at all to livestock animals, only to companion or domestic animals.
Thank you very much. Any other questions for the sponsor? Seeing none. On the amendment 6819, any objection to the question? Seeing none, we're now voting to add that on to House Bill 733. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We're on House Bill 733 as amended. Any questions for the sponsor? Question has been called. Any objection? Seeing none, we're now voting to send House Bill 733 back to full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail.
Thank you, Committee and
Move
Chairman.
on. Bill passes as amended. Thank you. Okay, members. There's a special calendar. And on that special calendar that we have here, item number 1, House Bill 924 by Vice Chairman Wright. You have a motion and a second. You're recognized.
Thank you, Mr. Chairman and committee. If I get my glasses on and get us started here. This bill authorizes law enforcement to use drones in 3 additional ways, and that where drones are already in code. This is law enforcement requested, this is district attorney drafted, and we've had 2 or 3 rewrites here, and I think you may have some testimony that people are wanting to present. So what's the pleasure of the committee?
Well, is there an amendment on this? I have one, 6228.
6228.
You have a motion and a second on that amendment. Question has been called on that amendment. Any objections? Seeing none, we'll vote to add this amendment 6228 on the House Bill 924. All those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt. We have folks that are here to testify. Do you wish to call them up? And question's been called on the bill. Any objection? For that point of order? Yes. Can we withdraw the question? Okay, motion's been withdrawn.
I'll make it quick. Thank you, Mr. Chairman, committees. I appreciate your indulgence. I just had a question, which may be a little off topic from the legislation, but there's a rumor going around town that there was a certain representative, last name Wright, that was in a coffee shop this morning and was asked if he resembled a very popular spokesperson of a certain fast food chain. Could you enlighten us? Could you enlighten us on that?
That is absolutely correct. Thank you, Mr. Chairman. The person addressed me, "Good morning, Colonel," and then he said, "Colonel Sanders."
Very good. Thank you, Mr. Chairman. I appreciate it.
Representative Russell.
Question on the bill.
There's an objection to the question. No. Okay. Question has been called on the bill. No objections. We're now voting on sending House Bill 924 as amended on the full criminal. All those in favor say aye. Those opposed, no. The ayes prevail. You move on.
Thank you, Mr. Chairman. Thank you, committee. That was at 5:45 or 6 o'clock this morning, right?
Item number 2 on the special calendar, House Bill 600 by Representative Hodges, will be sent back to the clerk's desk. Item number 3, House Bill 413 by Representative Lamar, will be sent back to the clerk's desk. Item number 2 from our regular calendar, HJR 44 by Chair Lady Hazelwood, will be sent back to the clerk's desk. Item number 17, House Bill 803 by Representative Griffey, will be sent back to the clerk's desk. Members, from all indications, unless someone else has a bill in their pocket that they're about to pull out, I think that we have completed our calendars.
Mr. Chairman, if I may be recognized, in fact, I'm going to go and insist on being recognized whether you recognize me or not here.
Sure.
I don't have a bill, but I will tell you that every single member of this committee, and we've been talking about you when you weren't around, have admired how you've done. I mean, you've done a phenomenal job on this committee. I know it was your first year chairing a subcommittee. But you really, really, really have done the hard work. Many of us have gotten calls late in the evening from you where you're studying bills, where you're reaching out to members. Many of us have not done as good a job as we should of calling you and asking, Mr. Chairman, hey, what posture's my bill in? What have you heard from other folks? And you have reached out to us, and all of us on this committee genuinely appreciate that. So, sir, I just applaud you, literally, for the hard work that you have done as our chairman and tell you that we truly appreciate you.
Thank you. Thank you very much.
By the way, Mr. Chairman, before you speak, I have a feeling there's somebody else that appreciates you even more than I do.
Well, GA is gone. He's not in the room. He left. Oh, okay. Chairman Curcio.
Thank you, Mr. Chairman. Yes, I want to echo that. It's been a pleasure getting to work with you this year. Thank you for not sending me bad bills to the full committee. I really appreciate that. But no, in all seriousness, doing a fantastic job. Thank you for the work you put into this. Everybody who serves on this committee or the Civil Justice Committee knows these are working committees, and you can't phone these in. So thank you for the work that you've done, extra hours, and also like me, you go home every night. So it's a long drive. And so I know you put a lot into this, a lot more than what the pay reflects. And people say this is a part-time job. It certainly is not. So congratulations on a great year.
Thank you. I appreciate that very much. I will say that this is, I would put this committee up against anybody. I've really enjoyed being, serving on this committee with all you. It's a team of all-stars. I honestly believe it. And so I would say that any criminal justice subcommittee across this country, we outwork them and could outdo them. I honestly believe that. So thank you all for working with me and helping me for all those times that I go out of service and say the wrong things and do the wrong things, and for correcting me. Thank you so much. Anyone else? Representative Hardaway, I hadn't recognized you in a few minutes. Do you wish to be recognized before we close?
Thank you, Mr. Chairman. It's been a pleasure working with you. Whether you're in service or out of service, you've been a terrific chairman no matter what. So looking forward to 2022 and making some good law.
Well, thank you very much. Anyone else? Seeing none, we will stand adjourned subject to call of the chair.
I don't know if I can. I do better with